Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 66, Wrestling Pigs and Unicorns. Hello and welcome to This Week in Law with Denise Howell. I am so excited to do this week's show because we have had a huge week in law, technology law that is specifically, and really, really fun stuff to talk about today. And a great panel to do it with. Joining us once again is Evan Brown from Chicago. Hello, Evan.
Well, hello. Good afternoon. Thank you very much for having me back. Great to be here.
Great to have you back. And from Massachusetts, we have Erik Heels. Hello, Erik. Thanks for coming back on the show.
Hi, Denise. Thanks for having me back.
Our pleasure. And from the West Coast, like myself, we've got Chris Ritter up at Stanford. Hello, Chris.
Hi, Denise. Pleasure to be with you.
Pleasure to have you. So I'll just introduce, Erik's been on the show before, so people may be familiar with him, but he's a lawyer in Massachusetts who does patent, trademark, and copyright work, I believe, and is a longtime blogger and internet denizen. So it's always great to have Erik back on the show. And Chris is a lawyer up in Northern California, a non-resident fellow at Stanford's Center for Information and Society. And I take it you're there for Stanford's e-commerce conference that's going on this week?
Yeah, exactly. Yeah, it's just a one-day conference, but it's a very exciting sort of overview, news you can use about all sorts of internet policies and practices.
Great. I really appreciate your taking time out to join us to talk about, one little tiny legal development this week, which is that the 3-year plus long litigation initiated by Viacom against Google over its YouTube service has been brought to a close at the trial court level by way of summary judgment in favor of Google. Let me ask you guys, when this case was filed, would you have ever predicted in a million years that it would be resolved by summary judgment in Google's favor? Evan?
Well, I was hoping so. I think, I like the ruling. I think it's great, obviously, for the role of the intermediary here. It's strange to think that it's been well over 3 years. I think we all knew that it was going to take a long time to get any kind of word on what was going to happen here. But I guess if I were a betting man, I would have said that the odds were against Google and YouTube on this. So to get to your question, I'm pleasantly surprised that it's turned out this way.
Yes, and we should explain for those not terribly familiar with the Byzantine legal processes that we go through in our country, that summary judgment is a way of disposing of a case before there is a trial. So the parties do discovery, they gather all the evidence that they think they might need, and they file a motion. Here there were cross motions. Viacom also moved for summary judgment in its favor, which it did not win. And they put on their best case for the judge, and they say, as a matter of law, there is no reason for this case to go to the jury because looking at these facts and applying the law, there is no issue left for the jury. We win. And here the judge actually agreed with Google that that was the case. Chris, did this kind of knock you over when it happened?
I'm not sure I was quite as surprised as some were. I think it's a pretty logical decision, but it certainly could have been something that could have been decided at trial. But I think ultimately it's the right result, and maybe I should end up playing devil's advocate later in the conversation. But I think ultimately it's in line with the other cases that have looked at online service providers. I think Viacom was trying to make it look more like a file sharing case, but I'm not all that surprised by the ruling.
How about you, Erik? Did it surprise you?
Well, I think it's the right decision, but it is summary judgment. In some ways, it would have been better to have the case decided on the merits because, Viacom's already announced that they're going to appeal. So I don't think we're going to see, final resolution of this for probably another 18 months. And even if they're successful on appeal, that just means the trial gets to go forward. So then you can tack on another 3 years after that, assuming they win on appeal. I don't think they will, but I think the internet community would like to have some finality on this sort of issue. And so it's the right decision at this point, but I don't think it's the finality that the internet community is looking for.
Right. What we should do here, I think, is give a little context on the case for anyone who hasn't been following it along in the media. And what the case involved was YouTube's liability, or Google on behalf of YouTube, as the host of the various videos that get posted up on its site, many of which infringe copyrights to this day. And Viacom sued over its catalog that was being used in that manner by YouTube's users. But the case didn't go after the users, as we have seen in other instances of copyright-related litigation, particularly on the RIAA's behalf. It went after Google, the intermediary, and suggested that Google had a responsibility to police and take down the various infringing works. There were tens of thousands of them that Viacom documented, and that the safe harbor provisions of the Digital Millennium Copyright Act did not protect Google from liability for its users' actions. Now, those safe harbor provisions allow service providers like Google and others to wait, sort of sit back and wait until they get specific notice of an infringing work. And when they do, there's a whole process that they're supposed to go through about taking it down. And then if the person who posted the work has an objection to that, they can come back and say, hey, this is actually not infringing for these reasons. And you can go through a song and dance about whether or not the work belongs on the site, is in fact infringing, etc. So Google, in this case, has been relying on those safe harbor provisions, and it turns out that they were its salvation on summary judgment. And I want to read you just a little bit from the beginning of Judge Stanton's decision in Google's favor that says, a jury could find defendants were not only generally aware of, but welcomed copyright infringing material being placed on their website. Such material was attractive to users whose increased usage enhanced defendants' income from advertisements displayed on certain pages of the website, with no discrimination between infringing and non-infringing content. Now, reading that at the beginning of the decision, you might have thought that maybe the court was going to go ahead and grant Viacom's motions for summary judgment. But that's not what happened here. Evan, can you explain for us generally why that particular bit of information that the court just laid out didn't matter?
It all goes to the question of what YouTube knew as to the presence of infringing content. And one way that the court characterizes the question is saying that honing in on some statutory language here, that the critical question is the meaning of these terms in the DMCA, what it means to have actual knowledge that material on the system is infringing, or to know of facts and circumstances from which infringing activity is apparent. So, to be honest, I wish Judge Stanton hadn't said that part about, actually welcoming infringing content on there, because that would, it just sounds bad. And it kind of paints the folks from YouTube in a bad light. At the same time, what we have here, though, is a reading of the DMCA. And, the court's opinion is very faithful to the language of the DMCA. A big portion of the 30-page opinion is essentially copying and pasting portions of the DMCA and the legislative history going about it. So the judge was very careful to stay faithful to the text here. So we hone in on this meaning of what it means to have knowledge of infringing activity. And at the end of the analysis, what we see here is that it's a very high standard, very particularized level of knowledge that the service provider needs to have before it can be considered to be on notice and therefore have to act expeditiously to take this stuff down or otherwise avoid infringement liability by being in the safe harbor on this. So that's why what we're saying there, that's how we can make sense of the portion that you just read here, because the real analysis goes to what YouTube knew or knows.
Right. Chris, you mentioned earlier that you might have a different take on the liability questions here. Do you think that the judge got this right?
I think the judge did get it right. And, one of the reasons the judge opened with that point, that a reasonable jury could find all these terrible facts, is to illustrate that those facts fundamentally didn't matter in the context of this case. What matters is knowing about specific infringing works. And if you have a knowledge that there might be sort of generalized infringement, that just isn't enough if you follow all of the rules of Section 512 of the DMCA. Right. And the court goes to great pains to go into, as Evan mentioned, the legislative history of the DMCA and the trying to glean out the intent of the legislators when they enacted this law in how specific the notice should be. What Viacom seems to have been pushing here is for a more representative, generalized knowledge of infringement to carry the day on liability and to cancel out the availability of safe harbors from liability. And the judge didn't go along with that and said, no, when we look at what the legislators were about here, we see that they wanted to be able to protect the ability of service providers to offer their services. We think that these kinds of services are important. They are valuable for communication and culture and everything else, and they're not going to be able to be offered if you put all the burden of policing infringement on the service provider themselves. One thing that I thought was interesting was the discussion of red flags, which is part of the DMCA and is sort of a substitute for notice under the notice and takedown provisions. You can either be exempted from liability if you comply with the notice and takedown positions. In other words, you're notified, you get notice from the rights holder. Or you can be imputed with knowledge if there is some kind of red flag. And Judge Stanton went through the discussion on how, and it's so funny to read some of this stuff from, the DMCA was enacted in 1998, and to see how things have shifted since then. A large part of the legislative history here discusses Yahoo and its human created database, which, back then was much more of a big deal than Google's search, which I'm not even sure existed in 1998. In any event, what the court got around to was if something is called, pirateyourvideohere.com, or there's some sort of blatant indicator that piracy may be involved, then that can substitute for knowledge. Do you think that, Chris, the red flag issue was treated properly by Judge Stanton here? And let me throw into that mix the fact that Viacom pointed out that at one point, Google had the ability for a community flag to notify Google that a work might be copyrighted. But as they point out on their site here, the number of days that YouTube's community flag allowed user to identify videos for copyright violations was solely 10, September 12th to 22nd, 2005. What do you think about this red flag issue? Well, I think the court took a relatively narrow view of what a red flag is. It's got to be some pretty serious indication that there is pervasive infringement happening. I'm not sure the court had to cut it quite that close to the line, but on the other hand, the legislative history is quite favorable to online service providers. So I think it was absolutely a reasonable way to go. And, with regard to the community flag, it's part of the problem in these cases, and I sympathize with Viacom. Like you said, things have changed a lot. And in the Web 2.0 world, I think we do have quite a bit more instances of infringing works, right? But it's extremely hard for people, whether it's the online service provider or the public who might be flagging content, to tell if a work is copyrighted or not, if it's in the public domain, if it's fair use, if it's been licensed by the person who uploaded it. And in this case, Viacom was alleged to have submitted a lot of its own works for the purposes of sort of viral marketing. And with so many reasons for a copyrighted work to be legitimately on a site like YouTube, it's just virtually impossible for anyone other than the copyright owner to successfully police it.
Right. I mean, as much as the court, I think, successfully distinguished this case from the Supreme Court's Grokster decision that Viacom continues to urge should carry the day here, it does seem like the principles not of Grokster but of Betamax, the even older decision that enabled us to have VCR technology. Although they're not specifically referenced anywhere in the opinion, they do come into play, I think, because we do get a lot of examination of what's going on the rest of the site and whether the site is primarily about infringement or about something else. Erik, what do you think about the Grokster and Betamax overtones and backdrop to this decision?
Well, it's as if we were really talking about two separate issues, and the judge was really alluding to that. I think, well, first of all, I think the DMCA is a bad law. And even though this is a victory for users and a victory for Google and YouTube, we're still left with a law that makes it far too easy for rights holders to take down information regardless of whether or not it's copyrighted and regardless of whether or not the use is fair use. So when he talks about how Viacom, who got a lot of bad press for having uploaded its own videos to YouTube, either in an attempt to seed the database with quote infringing works, or because they had finally figured out a business plan where they could figure out some other way of making money off of their digital content. The big issue is that there's two issues. There's the legal issue. Is this stuff copyrighted? Has it been copied? And is that copying allowed under the law? And then there's the business issue. Does it matter? And the thing that I think bothers me a little bit from a legal perspective is that the decision talks to, without really coming out and saying it, the does it matter business issue. And I've been arguing for 15, 16 years that it doesn't matter. But I think that leaves the door open on legal grounds for Viacom to win on appeal. And I'm hopeful that they'll change their business practices, but that issue is out there is troubling.
Mm-hmm. Let's talk for a minute about the safe harbors and what degree of specificity is required here. We have another case that is teed up for appeal in the Ninth Circuit, the VO case. Chris, you alluded earlier to the other DMCA cases out there. Can you give us the background of the VO case? It essentially also held that you need to have specificity in order for liability to attach, and that a generalized knowledge of infringement is not going to be enough. And it will be resolved on appeal, presumably, because it was resolved at the trial court earlier than this Viacom case will, so could have influence on the outcome. Can you bring us up to speed there?
Yeah, are you thinking about IO versus VO?
Yes.
Yeah, VO is actually kind of a frequent player in this area. And I'm not all that studied on it, but my impression is that IO versus VO is really one of the first cases to be very clear about following all of the little niggling rules in the DMCA, and if you do that properly, then the DMCA does what it says it should do. And I think this sort of, in a broad sense, highlights that copyright owners keep sort of coming back and saying, we struck this bargain with the notice and takedown provisions of the DMCA, and now, we really don't like it, or it really shouldn't apply because the rules are basically too hard for anybody to successfully follow. And I think in the VO case, they did everything right. They took down the content really promptly. They had an agent for service of process. I think it took a while for companies generally to recognize the importance of very technical compliance. And, we had VO and now we have YouTube. And I think that on appeal, that principle is definitely going to be upheld. I think you can ask whether in the Viacom YouTube case, a trial would have been a more appropriate way to resolve it. But so that's sort of my thought on VO.
Right. Well, if you listen to Viacom, the spin they were putting out right after the decision came out, the trial court process is just too long, let alone the fact that they filed the case, right? It's their fault. They're in a trial court. It's way too long. We welcome this decision, and now we can really get into it on appeal. So we wish them good luck with that process. And perhaps the VO case from the Ninth Circuit will have some impact there. Although just this last week, the poor Ninth Circuit has such a dismal record in having its decisions upheld by the Supreme Court, and it had 4 overturned just in the last week. So who knows whether it will be a factor or not on appeal. As Erik Schoenfeld pointed out over on TechCrunch when this news broke, the rights holders were the driving force behind having the DMCA enacted. And he summed it up by saying, live by the DMCA, die by the DMCA. And it appears that they have indeed done that here. Let's see. Evan, what do you think about the financial benefit piece? Because that's something that Viacom has come at over and over again with their papers and evidence here. And it's certainly a part of the DMCA that has been troubling to those on the Google side of the equation. That certainly, as the court pointed out in that language I read, the more traffic you get to infringing material, and infringing material generates more traffic, the more money a site like Google and YouTube makes. What do you think of the court's treatment of that issue?
I've often wondered about this particular question because it's tricky in the context of online video sharing. You remember, it's probably still around, but there was a video sharing site called Rever, and it was doing, it was appending video ads to user uploaded content early on, way back in like 2007. And in my mind, that seemed to really bring this nexus more tightly together. The revenue benefit tied to the actual infringement of the content. And I think this case does give us a more of an insight into that, because what the statutory language that we're talking about here is the right and ability to control. And I guess it's actually in the case law that arises from secondary liability for this, the financial benefit directly attributed to that. And then there's also this notion of the right and ability to control. And what the court does here is tie it into this same question of knowledge, that there really in this situation is not that ability to control it, because there was not the knowledge. We've already established, the court already established earlier in the case that there is not this knowledge, this specific knowledge of specific infringements that's necessary here. So, of course, it had to get through this element to make it through the analysis. But it comports with the rest of the opinion being very deferential to the technology provider in this situation. So it stays with the general theme of the opinion.
Right. What the judge seems to have done here is, in the case of the right and ability to control and the whole financial benefit analysis, is put it sort of last in line, saying that it only kicks in once the provider's on notice. And if you don't have the kind of specific item-specific notice that that is discussed in this decision, which is laid out in the various DMCA notices that YouTube received, then the financial benefit piece doesn't even come into play. So if you respond to the notices in a timely manner, then it doesn't matter if before those notices you came in, you've been making money off the infringing content. Chris, do you think, now obviously this case pretty much says that the safe harbors are not conditioned. In fact, it explicitly says that the safe harbors are not conditioned on any monitoring activity by the provider here, YouTube and Google. And the statute itself says that. And the court basically said, okay, the statute means what it means, and we're not going to impose on a provider the duty to do anything other than respond to either the red flags that we discussed before or specific notices of infringement. But given that, what do you think we are going to see Google do as far as changing its practices, if anything? Because it does go over and above what the court has said it needs to do here, and it does monitor and attempt to filter, as Viacom has complained that the filtering that was done for its works was not as extensive as the filtering that was done for various of Google and YouTube's partners, et cetera, was done at a later time. Do you think that Google will change any of its filtering activities because the court has basically said it doesn't need to do them?
I don't think they will change their filtering activity other than they normally would in the ordinary course of business. I think their filtering techniques have evolved. They have a few different programs in place. They have a digital fingerprinting for audio that is frequently, users make music videos or things users post often have audio. They sometimes filter that out. They have individual licensing arrangements with some of their content partners. But certainly as to the Viacom stuff, I don't think they're going to immediately do anything differently, nor do they have to.
Right. No, I think it's an interesting piece that, being a cautious business person trying to navigate its way through what have been, until now and until this is finally resolved on appeal and possibly in the Supreme Court, uncertain legal waters. Google has not only complied with the letter of the DMCA, but has gone beyond that. Erik, do you think that could actually wind up coming back to haunt them?
Well, it might, but following up on what Chris said, and something that you alluded to earlier, Denise, is, if I were Google, what I'd be doing is working on their crowdsourcing technology and trying to fine-tune that as a way of identifying content, because Google's biggest problem, frankly, is their success and their size. So just take Gmail, for example. There are 10,000 Gmail users for every Google employee, and I think the number for YouTube is probably comparable. So even given a positive ruling, it's going to be a huge burden, whether it's through automatic scripts or crowdsourcing or whatever, for YouTube to continue to comply with the DMCA. My hope is that finally some of these rights providers either put up their own platform. I guess Hulu was intended to be that, or just smarten up and realize that every single use isn't necessarily a bad thing for them, whether it's on their platform or somebody else's.
Right. I stuck in our show notes your ease of copying in the digital age article that was written quite a while ago. And I just wondered, it seems like you've struck this note a couple of times in your comments that you were sending the message back then. I think it was 96 you wrote it?
I wrote that article in 1996. I reread it, and thank you for linking to it for this episode. But I reread it today, and it was interesting. I tried to predict what was going to happen in the future with the web being distributed and whatnot. And I suppose with Akamai's servers, you could argue that came true. But it really breaks down into three pieces, right? There is the creativity that's involved in creating value, whether it's copyrighted content or whatever it is, right? Then there's the intellectual property rights that attach to that are granted by the government. And then there are the embodiments of that IP, whether they are individual copies of files or books or movies or DVDs or whatever. And there's really three different things. And I don't think that the publishing industry, the old school publishing industry, has yet understood that these things are separate and distinct, and that, even if their entire catalog were copied, it wouldn't necessarily matter because, like the Grateful Dead said, there's only one source of Grateful Dead music, and that's the Grateful Dead. So they didn't care that their fans were recording their shows and bootlegging them. In fact, they encouraged that, and so that speaks to the creation piece. And I think, and I said this, I think during the last TWiL, I think it really is a generational issue, and we're getting close to where we need to be. But I wrote that article. 1995 was declared by Newsweek to be the year of the internet, and if a generation is 30 years, then we're only halfway there. So we've got a while to go before the old school retires and goes away, and new thinking is in place, both at the board of directors level and the officers that are running some of these media companies. Right.
So another thing I put in the show notes is something from Viacom's page on the Google litigation, which is a set of bullet points entitled Things You Should Know. There are 11 of them. And presumably these are what they think, having gone through all of the discovery in the case, these are what they think are their most persuasive, at least PR bullet points in their favor. Evan, did you take a look at these, and do you think any of them helped them out at all on appeal?
Well, these are the things that you would expect them to think were important, and it's the things that were important in the summary judgment motion as well. Talking about vast amounts of numbers. The first thing you should know is the number of infringed clips in the lawsuit was 62,000. Plus videos. So the allegations in the complaint, that were filed way back in March of 2007, talk about this, massive infringement and talk about one thing that I picked up on when the complaint was filed in March of 2007 was their allegation, Viacom's allegations that they borrowed from the doctrine of adverse possession in real property, and not to make a related point, but to make something. Not isomorphic at all to this, but they were talking about the grand scale, and it actually went to the knowledge of YouTube, that the infringement was open and notorious on YouTube, and so they were trying to loved that borrowing that term. So they were trying to make the argument that this infringement was so obvious here that it should be rise to the level of a red flag here. So going back to these points that Viacom makes here, the things that you should know. To me, the theme that I see from them is just a description of this magnitude, this extraordinary amount of infringement of very important things, like the Comedy Central, The Daily Show, MTV content, and then just kind of painting a picture of how YouTube was neglectful of treating Viacom in the right way. So it's content that you would expect to see from them on this.
All right, so then the next question I have, let's assume that that Judge Stanton's decision actually survives its next two potential hurdles. One definite hurdle is it will be reviewed by the Second Circuit. That is, unless the parties settle. Does anybody think that is at all in the cards here? I mean, back when I used to litigate, if you won a slam dunk summary judgment like this, the other party usually came to you hat in hand with some sort of settlement proposal. Anybody think, before we go on and talk about the appeal, that's at all in the cards? Erik, what do you think?
I think it'd be great to settle, because otherwise I And if I were Google's lawyers, I would recommend, settle, because the alternative is going to be, at least 18 more months of this, and maybe 18 months plus 3 years. It's not going away. And following up on what Evan said about those 11 bullet points, I would respond to those by saying, if I'm Judge Stanton, it's not my job, Viacom, to fix your broken business model.
Right. So you said a minute ago you would think that Google would be motivated to settle. I could see that because they've got this decision. It's a trial court, a federal trial court decision, which is not terribly persuasive presidentially, but carries some precedential value, and certainly is a decision on the books that can be cited down the road, and it's not going anywhere. So they've got that in their back pocket. I think Viacom is motivated not to settle for just the same reason. But I don't know if these parties are really in the realm of the human economic calculus that usually goes on at this point. Do we really want to carry this through all the way, and it's going to cost so much money, et cetera? They may just at this point have said, damn the torpedoes, doesn't matter the cost. This is a make or break the company kind of issue. Evan, do you think settlement's at all a possibility?
Well, I think it is, and I would suggest that it might be a reasonable possibility because, really, is it a make or break the company proposition anymore? We could see from the summary judgment briefs when we were talking about those a few episodes ago, and there was a lot of commentary on them as well. The real focus of the evil that YouTube did was in the early days, and the practices have changed. Presumably, YouTube is even more conscientious now of the presence of infringing content, and it would appear to me that YouTube would have more to. This is one of those things I'm going to make sure I say right. YouTube would have more to gain by having some certainty now, namely the notion that it won't get turned over on appeal. That the value. Here's how I want to say it: the value of that would be greater than the benefit that they would get of being affirmed on appeal, because in reality, their mechanism and manner of doing things is well in line with any reasonable administration of a system, of a technological system. Viacom would probably agree that the way they do things now is much more reasonable under the DMCA than what it was in the early days of YouTube. So that would be the value proposition that I would see if I were in the position of YouTube and Google on this.
Right. What do you think, Chris? Is this something that's so important to Google that they want to keep this law on the books as opposed to anything that might subsequently come down from the Second Circuit or ultimately the Supreme Court of the United States? That they might go to Viacom with a big number and perhaps some additional conciliatory measures?
Well, sort of selfishly speaking, I'd love to see a good Supreme Court case on this issue, but I think it makes plenty of sense for Google to settle, and probably sense for Viacom to settle also. Assuming there's something they can agree on. I think really Google has the upper hand on the law here. This case is part of a trend, and it really, I think, sits squarely within a bunch of district court decisions that have all come out sort of the same way. And generally, courts have been very favorable to online service providers. So I think sort of obviously losing this case on appeal would be unfortunate for Google, but leaving the status quo as it is with a bunch of district court cases that all support their position is not a bad place to be. So if they settled it, they'd have a bunch of great district court cases out there, some of which are pretty persuasive. This is out of Southern District of New York, which holds a lot of sway in this area. And for Viacom, I think it would be a coup to get a really great decision for Viacom on appeal. And it's the kind of thing you might take a flyer on and say, if we win this thing on appeal, it's going to change everything. It could really shake up the whole industry. So that's the incentive for Viacom to go forward and sort of take a flyer on it, whether they want to make that kind of big bet or just make a deal with Google. I think both of them are really viable choices. It depends how much of an existential issue Viacom thinks this really is and how committed they are to going the distance.
Right. Well, who knows if this is all just spin and posturing and possibly settlement posturing. But over at the Progress and Freedom Foundation, one gentleman, Tom Snydor, has quite a tirade on how this is bucking a trend, according to him. Leaving aside the other DMCA cases that you're referring to, Chris, he thinks that this flies in the face of Grokster and the other P2P decisions that have said that you cannot build your business off the infringement of your users, and that cannot be the foundation of how you go forward. And that's what they claim. They have the evidence that YouTube did here. It gives us at least a clue of where they will go on appeal, that they're going to take issue with Judge Stanton distinguishing this from the Grokster line of authorities and say, that for secondary infringement purposes, they absolutely apply here, and we can show you why. So we'll see if that actually pans out. But yeah, I think it'll be interesting to watch in the next few months and see what happens before the oral argument stage of the appellate process.
Can I just butt in on Grokster for a second?
Sure.
In virtually all the file sharing cases, the courts, if not all of them, the courts have found that the DMCA just simply doesn't apply to them. Mm-hmm. And I don't think there's any question that the DMCA does apply to YouTube, which is the key distinction.
Right. Exactly. So, you might have, and that's what Judge Stanton prefaces his decision with is you might actually have some sort of liability that would attach on these facts, but you've also got this safe harbor and it prevails.
Yep. It's
the determinative factor here. Okay, so final point on this is, and this is what I was saying a second ago. Let's assume that they don't settle, that they go through the appellate process and Google prevails both at the Second Circuit level and ultimately at the Supreme Court, either because the Supreme Court declines to hear the case or hears it and finds for Google. What's next in the strategy of rights holders against properties like YouTube? Can we envision people, the rights holder side of the equation, actually going after the users here, the ultimate infringers? And I say that against the backdrop of Professor Grimmelman from NYU last week on the show, commenting that when you are a user watching something on YouTube that you know or suspect might be infringing, just because you're watching it in a streaming kind of way from the site doesn't mean that you might not be implicated by copyright laws, because sufficient copies are made on your machine so that you can view the material. So if you're someone who, is taking advantage of the fact that Google's search function actually still allows you to find unauthorized copyright material on its site, or what apparently is that, and watch it in a pretty, not too unpleasant or not a whole lot of roadblocks in your way to that kind of activity, and that the search functions actually will suggest, the related videos. So even though Google makes users who are uploading these kinds of materials breaking them into 10-minute chunks, because that's all you're allowed to do for copyright protection reasons, the search function actually, buffers that a bit by pointing you to what might be the next 10-minute chunk. And, the algorithms actually sort of help users out in that way. So where I'm going with this is are we going to see the users in the crosshairs if Google ultimately carries the day on this? Evan, what do you think?
I hope not. I hope that sensibilities evolve in such a way that big media, the side of the rights holders, whether they're big media or more independent type of creators, see the benefits of platforms like YouTube in a way that is like content creators and rights holders realized the benefit of the VCR in the mid-'80s after the entertainment industry was unsuccessful in killing off that technology. So I hope that those sensibilities change and we don't get ourselves into a situation like that, because if we were to do that, it would just be really ugly and depressing to be in a state of affairs like we were beginning in 2003 when the recording industry started its litigation campaign against all the individual file sharers, and the same kind of depressing mode that attaches to the U.S. copyright groups blitzkrieg kind of campaign against individual BitTorrent users now. So for all of those reasons, even though it's plausible from a legal standpoint, looking at the legal procedures and the legal mechanics that we could get there, I hope that good sense will prevail and lightness will triumph over darkness in all of this.
Mm-hmm. Anybody else have any thoughts, Chris, on the user liability piece?
Well, so I think if anybody does get sued on the user end, it'll be the people who upload videos to YouTube and not necessarily the people who watch them, even though watching them does generate liability. But, even without the DMCA, I think copyright owners are resigned to the idea that they're going to be playing whack-a-mole for the rest of their natural lives, right? It could be underground darknets. It could be, the BitTorrent sites, which have been falling one by one. But of course, people crop up with new ones. People start them in other countries. And even illegal sites have seen quite a bit of success. And it's difficult to take them down one by one. And I'm not sure exactly what the solution is, but suing YouTube users doesn't seem to achieve the long-term goal of monetizing content or achieving the type of control that they need to be profitable. So I would hope that's not the way they go, but it's certainly something we've seen in other industries, certainly the music industry and to some extent the motion picture industry.
Mm-hmm. And sorry, go ahead. Is that Erik?
Yeah, I was going to say it's like wrestling pigs, right? So we've tried a bunch of different things. You sue your users, it's like wrestling pigs. You just get dirty, and the pigs enjoy it. And besides, the users, whether they're uploading or downloading or viewing, they don't have any money. And now we have this case and others that show that the DMCA protects bona fide publishers. So where does that leave the rights holders? It leaves them, I think, with having to solve their problem, which is their business model is the problem. And I went ahead and just looked up Viacom's versus Google's stock over the last 5 years while we were talking about these things. And
that's just not fair.
Well, here you go. Okay, so here's the bottom line. Over the last 5 years, Viacom's stock is down 20%. And Google's is up 20%. So these are companies that are moving in two different directions. And Viacom's in the buggy whip market, and they need to get into a different market. They need a different business model, and it's not the law's job to fix their broken business model.
Right. And it's not YouTube's either, as I think this court has soundly opined. And I do think this question, as you mentioned, Erik, of harnessing the wisdom of the crowds or the ability of the crowds to flag things that would be infringing is an interesting one, but it's probably more of a headache than Google would ever want to take on. They've got their hands full, I'm sure, just responding to the DMCA notices they receive. If they also have to then, and at least they have some legal standards for how they respond to those notices. They have some very specific things that they have to do once a notice comes in. If they institute their own policy, as they apparently did for 10 days, where users can flag potentially infringing content, then you can just imagine the can of worms that opens up as far as administratively for Google and YouTube, having to go through and decide on a clip-by-clip basis, whether this is indeed something that infringes or perhaps fair use or what have you. Chris, any thoughts on that one?
Sorry, I'm not sure I followed it exactly. On
the viability of Google perhaps resurrecting this notion that its users could help it keep infringing material off the site if it only gave them that facility.
Yeah, it's not really an option that appeals to me. It might appeal to Google, but I'm concerned that there would be too much chaff in their wheat, that they would simply get really sort of uninformed opinions. A lot of content appears infringing, but it might not be. It could be sort of a first cut, but I think the thing the crowds are really best for is identifying content that is not in compliance with their community standards. So pornography and really offensive stuff and that kind of thing crowds are excellent at. With copyrights, you can have a lot of underlying licenses and complicated legal issues that can make it really difficult to tell whether something is infringing or not.
Right. It's all muddied up by the fact that during the course of this litigation, YouTube has partnered with so many content providers that a lot of the stuff on the site that might appear to be infringing isn't anymore because it's licensed and authorized to be there. So I could see where that's not a great solution for YouTube on a go-forward basis.
Yeah, it seems to me that it's just about as easy for the rights owner to go through YouTube and identify what is infringing. And I think as better automated tools become available, maybe they can, the content owners can crawl YouTube with a automated tool that can detect their content and then send notices that way, perhaps even automated notices. One thing in the court's opinion that really struck me was that Viacom sent a DMCA takedown notice to YouTube listing 100,000 specific videos they wanted taken down, and YouTube took them down the next day. So it is possible to do this on sort of a grand scale.
Yes, absolutely, and that's a point that Judge Stanton seemed to have found very important, that the DMCA process is actually worked. The notices, it had them down immediately. So going forward, that's the world we live in as far as YouTube and Google and rights holders go. And it'll be interesting to see what happens next in this litigation. What has happened next with Apple this week is that, I don't know if you guys are all Apple users, but if you have an iPhone or an iPad and you have gone to download an application, you have been met with Apple's new privacy policy, 28 pages long, in your way, requiring you to accept it before you can go forward and use your device. So David Sarno over at LA Times actually took the time to look through those 28 pages and noticed that what Apple is giving itself the permission to do is collect location-based data on its users that is then being shared with third parties in various ways, and users are given the opportunity to opt out of specific sharing that might happen on an application-by-application basis. I'm not sure if they also have the ability to opt out entirely in a general way from having their information shared with third parties, but that may be the case. Anyway, this has attracted a lot of attention, even though the original LA Times piece went on to update itself and specify that Apple has actually been collecting this information from us, for quite some time now, since 2008. But it's been in their device-specific privacy policies, and now it's been moved over to its general privacy policy, and that's how it came in front of everybody. What we've got here is some folks who are up in arms about this, including Congressman Ed Markey and Joe Barton, who have written to Apple with a series of very pointed questions about this, which I think is really interesting in its own right, that we have a couple of congresspeople responding to and actually citing this LA Times piece that we've been discussing and asking a bunch of legal-related questions about the privacy policy and asking Apple to justify how its policy of collecting consumer location data comports with applicable laws. Evan, did you take a look at this, and what do you think of the letter, and do you think we'll get any response from Apple?
Joe Barton is just doing anything he can to take the attention off of himself for apologizing to BP. So his motives, I don't know, are pure in this. He probably doesn't care about privacy. Seriously, though, I don't quite understand the significance of what Apple has done here, moving it from a device-specific privacy policy to the general privacy policy. So until I understand, the effect of that, my comments on it are a little bit limited. Other than to say, it's strange that this is just now coming to everyone's attention, if it indeed has been like that since 2008. And the other point being, toward the end of this article. I guess Android phones do the same thing, right? And the privacy policy concerning those is even more cryptic, so to speak. So this is just, this type of issue, we're presented with different iterations of it all the time. This just happens to be one particular incarnation of it here. As we, as a culture, become more mobile, and we need to deal with a reliance on geolocation technologies and functions that rely on where we are. This is just one of those areas where there's going to have to be a trade-off. There's going to have to be responsibility here, and if we want to take advantage of all of these wonderful things that the technology, that these enhancements of mobile technology will provide to us, we're just going to have to toughen up a little bit and make sure that the proper framework is in place to keep things protected. One of the things I wanted to talk with Professor Grimmelman last week, but we didn't get around to it, was the Rylands versus Fletcher, the old tort law. I know I've brought this up before. Strict liability for people who have big pools of important stuff that can cause harm to someone else. That's the real sensibility that we need to have in these providers like Apple, who have all of this data. Even if it is collected in a way that makes it anonymous, could be re-identified. The prospects are scary, so that scariness is what needs to be addressed on this, not just that the sky is falling automatically.
Well, there are a couple of interesting points in this letter from Congressman Barton and Markey to Steve Jobs directly. One is their reference to Section 222 of the Communications Act, which mandates that no consumer location information be shared without the explicit prior consent of the consumer. And they are asking Steve to go ahead and tell them how it is that their collection of this data comports with that provision. And also, and as a footnote to that, has Apple or its legal counsel conducted an analysis of this issue? If yes, please provide a copy. If not, why not? So they're really calling him to the mat on that. But the other thing that I thought was really interesting here was these congresspeople, being, whether or not they've apologized to BP or not, being good representatives for their constituents and asking the tough question: does Apple believe that legal boilerplate in a general information policy, which the consumer must agree to in order to download applications or updates, is fully consistent with the intent of Section 222 and sufficient to inform the consumer that the consumer's location may be disclosed to other parties? In other words, flagging the fact that nobody reads these 28-page policies when they're thrown in front of them. They click yes and they download their app and they go on their way, having no idea what they've just agreed to. And so the viability and enforceability of those kinds of policies is called into question. Erik, is Mr. Markey your congressman by any chance?
I think that's a good question. I think he may. I think he may be. The thing is, technology is not is not inherently good and is not inherently evil. Technology just is. And all these, it's interesting that the congressmen are concerned about devices that are going to disclose your location. Maybe that's fodder for a different TWiL. But the same device that can disclose that you're off someplace where you shouldn't be is also the device that can provide you with the enhanced 911 capability to save you in case of an emergency. So, it's a double-edged sword. Like Evan said, if you want to use these great technologies, there's going to be issues, because that which can help can also hurt, and it's sort of related to the whole Facebook privacy brouhaha. If you post stuff online, it's probably going to become public, and you shouldn't assume that it's going to remain private. And I think if you're carrying around a device that has a GPS in it, you probably should be aware that it can figure out your location at some point, whether for good or for evil.
Yep. What do you think, Chris, in your role as someone who works with CIS at Stanford? Do you think that it's good that attention seems to be paid to these things when they're happening now? For years, people just would assent to various EULAs in terms of service without really giving them much thought. But they do seem to come under scrutiny now, and Congress people write to CEOs, et cetera. Is this a good thing? And do you foresee any change in the future?
Well, I think it's a tremendously good thing. We've had issues with consent to these kinds of boilerplate contracts since the shrink wrap license was invented in the good old days before there was the internet. And I think the impact of a lot of these terms is really hitting home for people, especially in the privacy arena, but in other arenas as well. And I think I may disagree a little bit with Evan and Erik on sort of, if you want to enjoy these devices, you have to do whatever the device owner dictates. One issue is retention of the data. How long is it retained for? For you to call E911, they need the data for, let's say a couple of weeks. They don't have to retain it for a couple of years, but they typically do. And similarly, what kind of security is being provided by the company that hosts these vast databases, and what are they collecting? And I think at the least they should be transparent with the public about what's being collected, how long it's being retained, what it's being used for. It's extremely common to bury in these contracts that we may share data with our affiliates or third parties to help provide you services, and it's just so vague that it's extremely difficult to tell what's going on. And I think especially with location data, knowing where you go, knowing who all your friends are is also very sensitive, but knowing where you go is very useful to, stalkers. There could be personal safety issues. And, it's one of the more sensitive types of data available about you.
Well, right on the same subject line as this, not quite identical, but similar, is our first resource of the week, which is going to be the site at portabilitypolicy.org, and specifically portabilitypolicy.org/generator, which, if you are a web-based company, enables you to generate a portability policy for your site. And what these folks are up to, it's Elias Bizan and Steve Greenberg have sort of spearheaded this and founded the site portabilitypolicy.org. They've been inspired by Creative Commons and the fact that what we've been talking about here, EULAs in terms of service, are not exactly user-friendly and hardly ever read. They want to facilitate a way for people to know what is being done with the data, what they may do with the data that they are inputting into sites. So as Steve Greenberg puts it, in the same way that your privacy policy tells visitors what you can do with information they provide, your product's portability policy tells visitors what they can do with it. So it's sort of, data in, data out. And they are working on a way to have this be machine readable as well as readily human readable. and communicate to people, how exactly they can get their stuff out if they can, and what they can do when they close their account, that sort of thing. So, Evan, I know you had a post about this. Any quick thoughts before we go on to the rest of our resources and our tip?
It's interesting to consider, if you would, a Venn diagram that has one set being privacy and the other set portability. And I think there's a large overlap. There's the, portability, knowing where your data is and how you can get rid of it, port it out of there, so to speak, is a big part of, that's where the big overlap is. The really interesting part, and I think where the innovation is coming from here, is in that part of portability that doesn't overlap with privacy. And it's a consequence of the technologies, the openness of technologies, open APIs, and the ability to use different platforms to accomplish similar means is what really gives rise and makes this thing so interesting here. So I'm glad to see the attention to it. And it's cliche to say as with the increasing use of cloud computing services and platforms, this type of analysis will become much more relevant.
Right. The other thing I think people should check out is over at EFF. Our other resource of the week will be EFF's HTTPS everywhere resource, which is something that enables you to add browser security to sites that don't already have them. So, for example, email for a long time didn't have that as its default, and now it does. But for other sites, HTTPS everywhere over at EFF.org will help you ensure that your data is being moved around the web in a secure way. And finally, on to our tip of the week, which is a great one this week. And it would be that when you are going to send a cease and desist letter about a product that you believe infringes a trademark, make sure that the product is real. And this comes to us from the folks at ThinkGeek and their fabulous April Fool's extravaganzas that they do each year. I think it was just this past year, they had unicorn meat as a product that was supposedly available on their site, but of course wasn't. That didn't stop the enormous internationally renowned law firm of Fager and Benson from sending them a detailed 12-page cease and desist letter asking that on behalf of the National Pork Board that they no longer offer that product for sale. And of course, it was never for sale in the first place. Evan, you sent this my way. How long were you on the floor laughing about this before you could get up and send it to me?
Yeah, until about 5 minutes before the show started here. Bless their hearts. I mean, I cannot imagine any grievance so atrocious that it would require a 12-page cease and desist letter, legitimate or not. So, this is just the attorney who wrote the letter has been able to remain anonymous. The site was able to, blocked it out, and I don't think who it is. And it came from the Denver office.
That was kind of them.
Yes, and I have friends in the Fagery and Benson offices in Denver where this came from. So I really hope it's not you, because we'll still be friends. But gosh, what are you thinking here?
I think they're thinking about a new business model. There is no such thing as bad press anymore, right? I look at that and I said, I don't think that was unintentional. I think they knew full well that it was going to be roundly criticized and that they were going to be laughed at. Yet all we're talking about is the other white meat. And everybody that's been laughing about it, next time they're in the grocery store, they're going to say, hey, maybe I'll buy some pork this week. I bet pork sales increased as a result of that story, which is, I think, what their goal was.
I think there was actually there was another letter they could have sent that would have increased their sales just as much, which is a letter saying that we think this site is hilarious and please feel free to use our trademark only for the website and for making people laugh. And they would have got a lot of attention for being a good citizen and having a good sense of humor.
And smart, but...
Yeah, and smart.
Well, I can see a way we could combine those two things and write the serious letter but be sure to print it on a color copier where all the words are in different colors, a lot of rainbows and stuff on it. That would be to stick with the unicorn theme.
Like the unicorn meat can itself over at Think Geek. Well, they had no end of fun with it and have product promotions where you can actually take $10 off any order of $40 or more by using the code PORKBOARD at checkout, good until 6/30/2010. So go ahead and take advantage of that. And they also highlight, of course, all their bacon-related products available on the site, which are plentiful. So thank you, Think Geek, and thank you, unnamed lawyer at Fager and Benson, for the hysterical moment in our week in law. And with that, we'll go ahead and wrap the show. Thank you so much, all of you, for taking the time to discuss all this fun stuff. Chris Ritter up at Stanford, thanks so much for joining us.
Thank you.
Where can folks find you online, and where's your firm?
They can find me at critter.com. My firm is Ritter, Costa, and Johnstone in San Francisco.
Great. Real pleasure having you. Erik Heels, thanks so much for returning to the show.
Thanks, Denise.
And folks can find Erik online at, he's at Erik J. Heels on Twitter, erikjheels.com, and Clock Tower Law over in Massachusetts. So thank you so much for joining us.
Thanks for having me again. Our
pleasure. And Evan, the perennial Evan from at internetcases.com. Actually, you're not going to be joining us, not next week, but the week after, right?
That's right. I'll be with you next week for the Independence Day edition of the show, right? And,
good. Yes. We'll bring fireworks.
Yeah, I'll be off July 9th. But thanks for having me. And Chris, nice to meet you. One of your law partners is a former colleague of mine, Erica Johnstone, right?
Yeah.
Isn't that who the Johnstone is? Yeah, she was in the San Francisco office of my firm, Hinshaw and Culbertson, before she joined up with you. So it's a small world after all. Great to talk with you. Great to meet you. And Erik, good talking with you.
Likewise. Laser show.
As always.
All right. Thanks so much, all. We'll see you next week.